We're here to discuss some issues of interest in the field of shareholder protection today. My name is Tony de Garr Robinson. I'm a commercial silk at 1 Essex Court, with, it's fair to say, a long background in commercial chancery work, particularly fraud, company and insolvency. I have the dubious distinction of being involved many years ago in one of the longest ever unfair prejudice trials, which lasted over a year and which involved virtually every unfair prejudice argument it's possible to think about. But I try not to think about that case too much. Ed Nourse is also a silk at 1 Essex Court with a practice in commercial litigation, including fraud and group litigation. He regularly advises and acts in shareholder disputes, and notably acted for the Berkeley brothers in their dispute over the ownership of the Connaught, Claridge's and Berkeley hotels, the well-known Re Coroyne litigation. Sophie Weber is a senior junior at 1 Essex. She has a broad commercial practice with particular emphasis on jurisdictional disputes. She also undertakes government work as a member of the Attorney General's C panel. Her company law expertise is testified to by the fact that she appeared for the successful appellant in Marex Financial Limited and Carlos Sevillea, a case whose name I can never pronounce, last July, where the Supreme Court refined, it's fair to say, that's a modest term for what they did, with the scope of the rule against the recovery of reflective loss. I feel it necessary to mention that Sophie is fluent in Luxembourgish, French and German, which I find extremely intimidating, and is very useful for many clients involved in transactional disputes if you're out there. Now, today, we're not talking about transactional disputes, we're talking about quasi-partnerships. Everybody sitting, looking at their screens will know that for a very long time, courts have exercised powers to protect minority shareholders from the unfairness inherent in there being a risk of oppression by majority shareholders who are in control of the company. Various mechanisms have been developed for the protection of such people. For example, derivative actions where there are breaches of duty by directors. The possibility of derivative claims, of course, used to be wider. And there are two mechanisms in particular which are designed to do much more than merely protect against unlawful conduct by the controllers. Those two mechanisms are winding up on the just and equitable ground. That's the nuclear option, and Ed will be discussing that in a few minutes. And then there's the statutory power to intervene without destroying the company, introduced in 1948 to deal with situations where the affairs of the company were being conducted in an oppressive manner. That statutory power was reformulated in 1980 as a power to intervene where the company's affairs are being, or have been, or are going to be conducted in a manner that's unfairly prejudicial to the petitioner's interests as a member of the company, now to be found, as everyone will know, in sections 994 to 996 of the Companies Act. The easy case for intervention is where the controlling directors and shareholders are acting in a way that's unlawful vis-a-vis the company. Provided their wrongful conduct prejudices a minority shareholder's interests sufficiently seriously, the shareholder is likely to have a remedy. They may not even need an unfair prejudice or just an equitable remedy. But what about the situation where controllers are behaving entirely in accordance with the company's constitution and with their duties as directors, but the effect of their majority control causes serious prejudice to one or more of the minority shareholders? Now, this is where just and equitable winding up and unfair prejudice come in, of course, but it's important to make clear that the court can't intervene whenever it has a subjective sense that a minority has not been treated fairly. It can't give a remedy in a small company based on trust and confidence, merely because that trust and confidence has broken down within the company, or even because one side is at fault for its breaking down. Otherwise, the courts would be overwhelmed by claims of unfair prejudice, and many of those claims would require so much factual investigation that trials would be impossibly long, and I speak from personal experience. So the courts have developed principles designed to operate as a control device to limit the circumstances in which unfair prejudice claims can be brought successfully. The leading case, as everyone will know, is the decision of Lord Hoffman in O'Neill and Phillips. One situation where the courts frequently intervene is what's known as quasi-partnerships, a phrase which was coined by Lord Wilberforce in a just and equitable case, Ibrahimi and Westbourne Galleries in 1973. That was a partnership between two equal partners, which had been transformed into a company where profits were distributed by way of remuneration paid to the directors. The son of one of the partners joined the business, and to cut a long story short, the father and son voted to exclude one of the original partners from the business and from participation in profits. The House of Lords held that the removal was perfectly lawful as a matter of company law, the exercise of the shareholder right to remove a director fully in accordance with the Articles of Association of the company, but the exercise of that right was subject to equitable considerations arising out of personal relationships forming the basis of the shareholders' association. So in this way, considerations of a personal character between the shareholders can operate as constraints, making it unjust or inequitable to insist on legal rights or to exercise those rights in a particular way. And action contrary to those equitable constraints provides a basis for exercising the court's jurisdiction to wind a company up on the just and equitable ground. And now in more modern times, more frequently, it's a basis for exercising the court's unfair prejudice jurisdiction. Now, when does a quasi-partnership arise? The well-known quote from Ibrahim of Lord Wilberforce, he says, "The superimposition of equitable considerations requires something more, which may typically include one or probably more of the following elements. One, an association formed or continued on the basis of a personal relationship involving mutual confidence. This element will often be found where a pre-existing partnership has been converted into a limited company. Two, an agreement or understanding that all or some, for there may be sleeping members of the shareholders, shall participate in the conduct of the business. And three, restriction upon the transfer of the member's interest in the company, so that if confidence is lost or one member is removed from management, he cannot take out his stake and go elsewhere." Now, it's important to understand, as I imagine that most people listening to me now do understand, that these are common features of a quasi-partnership, but none of those requirements are either necessary or sufficient. Some may well be missing, but they give a good sense of the sort of situation where removal from management could provoke a court to give a remedy. Now, definitive guidance as to the underlying principles, not only in quasi-partnership cases, but more generally, is given, as I said, by Lord Hoffman in O'Neill and Phillips. I don't have time to tell you the facts of the case. It was an admitted quasi-partnership case. The Court of Appeal held that a 25% minority shareholder who'd been running the business for 50% of the profits had a legitimate expectation that he would receive 50% of the shares in the company and would continue to receive his share of the profits if certain targets were met. It ordered the majority shareholder who'd resumed control of the company to buy him out. This gave Lord Hoffman an opportunity to explain the juridical basis of the equitable constraints which provide the grounds for intervention, both in the just and equitable jurisdiction and indeed the unfair prejudice jurisdiction. Unfairness, Lord Phillips noted, required more than action which was contrary to a minority shareholder's expectations, even if the expectations were encouraged by a majority. What was required was an equitable constraint, giving rise to a correlative equitable entitlement or right. And moreover, unfairness only arises in circumstances where it's unconscionable for the majority to act in a way that infringes that right. Now, this is where it becomes helpful to discuss the last case in my list, Edwardian Group Limited, a decision of Mr. Justice Fancourt in 2018. It's a long case, but it's instructive on many quite important practical issues, including what is required for there to be a quasi-partnership, how one deals with a situation where the minority shareholder is removed, but he himself does not have clean hands, the impact of delay in bringing a claim, and whether and to what extent the court requires a minority discount to be applied when buyout is ordered, but the company is not a quasi-partnership. In that case, the judge applied quite an innovative solution, which is finding favour with some courts. It gives the courts the power, as I was discussing with Ed before this talk, effectively to split the difference between a claim for a full minority discount and no discount at all. Now, it's a useful case on quasi-partnership because a number of ingenious arguments were adopted in support of the contention that the petitioner was a quasi-partner who had been unfairly removed as a director and unfairly dismissed as an employee. The contention was rejected, but it forced the judge to consider quite deep principles applying to this particular relationship that often triggers judicial intervention. In particular, it required him to consider the difference between having an expectation of participation as a director and senior manager, which the petitioner in that case clearly had, and believing that one had an entitlement of such participation. The facts were complicated, but the case is a graphic illustration that the threshold for having an entitlement is much higher than one might think. There needs to be a special equitable obligation. A mere expectation or even understanding is not enough. It needs to be an understanding of an entrenched entitlement. And there needs to be mutuality of benefit or burden, or at least detrimental reliance on the understanding, making it inequitable to deny the obligation. Usually, not always, but usually, a promise is required, if not expressed, then implied from conduct. And that sort of promise can be negatived, for example, by a shareholder agreement that provides that it supersedes all previous agreements or understandings between the parties, a point that is often worth bearing in mind. Now, the facts of Edwardian are as follows. It was a family company which grew into a hotel group that was worth far more than £100 million, and it operated on very professional principles. But it was established by a brother, Jasminder Singh, as a family company, albeit one in which there were some outside shareholders from time to time. The judge found that there was an understanding that Jasminder, the older brother, would use his majority control for the benefit of his wider family, his parents, and his younger brother, Harinder Singh. There was a hope and expectation, a mutual hope and expectation within the family, shared by Jasminder, that Harinder, who became a director when he was very young and then became an employee as soon as he qualified as an accountant, would take over as Jasminder's successor. And Jasminder told his brother at various times that he regarded him as his Prince of Wales. There was also an understanding, so the judge found, that the brother would have a long-term senior management role if he proved himself. But that qualified understanding was not enough to give him an absolute entitlement, making him a quasi-partner. So the first aspect that's worth drawing to your attention about Edwardian is that it contains a really helpful examination of where the dividing line is between a mere expectation of participation in management, which is insufficient to create equitable constraints, and an absolute agreement or understanding of entrenched entitlement to participate, which is sufficient. The second aspect, which is worth considering about the case, is this. Is a quasi-partnership limited to cases of closed companies where all the shareholders are parties to, or at least aware of, and acquiesce in the relevant agreement or understanding? Now, it's not a problem if there's an outside shareholder which is a nominee for an insider. There, practitioners take it as read, the nominee will be identified with its ultimate beneficial owner. So, for example, if the beneficial owner has an understanding as to his entitlement, whether a quasi-partnership understanding or some other understanding operating as a constraint on what would otherwise be the rights of the shareholders and directors, his nominee, which holds the shares for him, will be able to seek relief on the basis of that understanding, even if the directors of the company knew nothing about it. Now, that's taken as read, but it was helpfully argued out on a strikeout application before Jonathan Crowe, sitting as a deputy judge in the case of Atlas View in 2004, and you'll see that that's on the list. But what if there's a real outsider who was not aware of and was given no opportunity to accept the quasi-partnership understanding? Here we have some divergent authorities, all of which are obiter. There's a Hong Kong case of Yung Key Holdings in 2014, which suggests that as a matter of law, there is no absolute bar to prevent the operation of equitable constraints arising from dealings between particular shareholders, provided that applying those equitable constraints doesn't prejudice shareholders who were not party to the relevant understanding. Now, this point was argued out in Edwardian in 2018. Mr. Justice Fancourt expressed extreme doubts about it, in my respectful view, correctly. The status of a quasi-partnership arises from the character of the company. in which there's a mutual understanding of trust and confidence akin to a partnership. The judge accepted that a quasi-partnership may exceptionally exist where a small shareholding devolves to an outside shareholder, which is what happened in a case called Fisher and Cadman in 2006. But beyond those exceptional cases, if significant shares are held by an outsider, then enforcing personal obligations gives rise to problems. Invariably, what the court is dealing with is not just a matter of shareholders who've agreed to vote their shares in a particular way with other shareholders. Now, that's perfectly possible. Two individual shareholders can come to an agreement about that whenever they want. But generally speaking, unfair prejudice claims also involve allegations that the directors are managing the company in a certain way which is inappropriate, for example, by removing someone as an employee. Now, in that situation, outside shareholders are entitled to expect directors not to be constrained by some private obligation which they've not accepted. So the balance of the English law at the moment, all these cases, these two cases, the Hong Kong case and the English case, are all obiter, but the balance of learning at the moment is that to be a quasi-partnership, everybody in the company needs to either have be party to the understanding or at least be aware of it and acquiesce in it. That brings me to a third interesting aspect, which is what happens if the shares, a substantial number of shares in the company, are held by family trustees. Now, that's not an infrequent situation, even in small companies. It's tax efficient for company shares to be held by offshore trustees on discretionary trust for the settlor and his family. That was the position in Edwardian. I acted for the majority shareholding trustees who removed the younger brother, Herinder, as a director. And so I had cause to consider this area of law quite carefully. If we start with first principles, there's a decision of Garr Robinson QC, sitting as a deputy judge in Hills and Jamar in 2011, who held that if trustees connected with one of the directors acquire shares in a company, a fresh equity has to be shown to arise, binding the conscience of the trustee. Now, in Edwardian, Herinder, the younger brother, attempted to argue that family trustees were party to the alleged quasi-partnership understanding. That argument failed on the facts. The Jersey trustees' knowledge of the business was quite limited, and they knew nothing about the alleged understanding until the younger brother started complaining about his removal. So the brother ran some alternative arguments. These are quite interesting, and it's important to note that they were all rejected by the judge. First of all, the judge held that trustees are not to be identified with their principal beneficiaries. In this case, there were two trusts, and the principal beneficiaries were the two brothers, older and younger. They were discretionary trusts, and the trustees had duties to a wide class of beneficiaries, including unborn beneficiaries. They were nothing like the nominee company that existed in the Atlas case. By the way, it's important to note that this meant that even if the younger brother Herinder had had a valid unfair prejudice claim against his older brother for procuring his removal, the court would only have ordered a buyout of the younger brother's own personal shares. It would not have ordered a buyout of the shares held by his family trust. And that is a point worth remembering. Second, the judge held that there was no room for argument that when the trustees acquired their shares, they were impressed with the brothers' prior quasi-partnership understanding. That property sort of analysis was held to be wholly inapt for a variety of reasons. One of them was that for a shareholder's rights to be affected by equitable considerations, there must be a direct personal relationship or arrangement affecting that shareholder's conscience. It's a point that was made very clear in the Coroyne litigation that Ed was involved in. Third, the judge held that it did not help the younger brother to say that trustees were complicit in the older brother's allegedly inequitable desire to get rid of him. The simple point was that the trustees' right to remove him as majority shareholders were unfettered, and they could do what they wanted to. All of this was obiter because Tim Fancourt held that there was no quasi-partnership understanding anyway, but it was argued out in painful detail, and the judge helpfully dealt with all of the arguments. It's important to be aware of it, in my view. So the conclusion for present purposes is that where you're faced with a company with significant shareholdings held by outsiders, you need to think very carefully about whether claims based on personal dealings can be maintained. And where shares held by discretionary trustees, the position could be even more complicated than that and not less. So with that, my part of the talk is over, and I'll hand over, I think, to Ed.
Good afternoon, everyone. I'm going to talk briefly about some points on just and equitable winding up and suggest that there's still some life in the old remedy. Since the 19th century, if not before, the courts have been winding up companies on the basis that it's just and equitable to do so. But by the end of the last century, the 20th century, the remedy was almost extinguished, overtaken by the newer upstart remedy of unfair prejudice petitions, which, as Tony points out, came in its current form in about 1980, and now it's under Section 994 of the Companies Act. By the end of the 20th century, some judges seem to think that the newer remedy had effectively supplanted the old, superseded it, so that there was no sensible reason to seek the more extreme remedy. All cases justifying that remedy of the winding up would also amount to unfair prejudice, so the argument went, so you would always give the buyout rather than the nuclear option. But it's clear that some cases will still lead to a just and equitable winding up, where no remedy would be available for unfair prejudice. And there might be particular reasons why particular types of petitioners might want to seek the older remedy, or at least argue for it. And I just want to point you to some of the possibilities rather than giving definitive answers, since one of the things that's very clear in this area is that the range of the problems, and so the range of the answers, is myriad. And all the leading authorities stress that the remedies are broad and discretionary, and there is at least a view that easy categorizations are to be avoided, although there's a contrary view, which I think Tony obviously agrees with, that cases like O'Neill are precisely trying to provide some rules to cut down the scopes of the remedies. Also, the interplay between the just and equitable remedy and the unfair prejudice remedy can be complicated. So as I said, it's clear that there are still certain types of cases in which a winding up is available where there would not be an unfair prejudice case available. A classic example of what are called the loss of substratum cases, where the whole basis for the company has gone, but through no particular fault of any particular party. So a classic example from a long time ago is of a company that was set up to make coffee from dates through a particular patented German process. It sounds absolutely disgusting, and it didn't work. But what the court held was that the company couldn't carry on using some other process, a non-patented German process, to make coffee from dates, rather than using the particular one for which the company had been set up. And so it wound up the company. More significantly and more common, I think, are the true deadlock cases. And that's normally where the parties are 50-50 shareholders, perhaps in a joint venture company, and there's no board majority, and they're unable to agree, so that the company can't function. And it's important that it has to be that the company cannot function. There will be no true deadlock if it still can, for example, because the director has a casting vote. But if there is a real deadlock, the court will still wind up, even in the absence of fault. So there may not be anything unfair at all in such cases, no breach of duty of any sort by any party. The parties to a joint venture might simply be taking a reasonable but different view as to whether, for example, they want the company to expand or to carry on or to make a particular investment. And it may be that they then get into a position where the company is simply stuck. But in those cases, even without fault, where you wouldn't therefore get an unfair prejudice petition off the ground, or likely, you can still get the winding up order, which is, of course, as Tony points out, the nuclear option. And that's why so many joint venture agreements, or at least sensible ones, will contain provisions precisely designed to avoid this result in the event that the parties can't reach agreement usually by some form of buyout mechanism to replace the winding up. So if you are in one of those sorts of scenarios, it's likely that you'll obviously seek the older remedy because it's the only one you have. But there might be other potential reasons why you'd want to seek the winding up remedy. And I think that these will likely apply particularly in circumstances where you're not in a quasi-partnership. And Tony has obviously just spoken about what that category involves. And Sophie will be saying something about remedies, which may well depend upon the question of whether you are or are not in a quasi-partnership scenario. I don't think it's stealing her thunder too much to say that the courts are more likely to order a buyout on a pro rata, undiscounted basis where there is a quasi-partnership. But assume you're not in a quasi-partnership. You may face the prospect that if you were to achieve a buyout, it would be at a very substantial discount. The cases have gone from anything from 40% up to 60%. And even under the revised Edwardian approach, you're still looking at a significant potential discount. In such a case, you might be better off as a minority with a winding up rather than a buyout at a heavily discounted price. Of course, it will depend upon the liquidation value of the company. If it were to be wound up, a trading company is less likely to be not to suffer such a significant discount. But if you had an asset holding company, then it might be that you would be better off winding up the company than getting a heavily discounted buyout order. So you'll certainly want to think about what the financial position is up front. But assuming you are better off going for a winding up, you may prefer that option for perfectly legitimate reasons. And another reason that you might want to seek a winding up rather than the unfair prejudice petition is that it's at least possible, and I say no more than that, that the test could be satisfied, is lower than that you might need to obtain a buyout, perverse as that might seem. That might be particularly so in a non-quasi-partnership case. So the case I want to refer to in this respect is the Chu v. Lau case, which is at the top of my list. It was a quasi-partnership case where two substantial Hong Kong businessmen had fallen out spectacularly with each other over the direction of the company and its subsidiary. Roger Kay was sitting as the judge in the BVI where the company was registered, and he held that this total breakdown in relations justified a winding up. A winding up was the only remedy that was being sought by Mr. Chu. As in all winding up cases, the burden was on the respondent, i.e. Mr. Lau, to show that the petitioner was being unreasonable in not pursuing another remedy, such as a buyout. And the Privy Council upheld Roger Kay's decision that the respondent had not satisfied that burden, i.e. that the company could be wound up. Roger Kay relied on the fact that the respondent might not be able to afford a buyout, which is an obvious point for consideration in all cases. However, additionally to this, and as summarised in the words of the Privy Council, the judge held that it was not unreasonable not to seek a buyout, quotes, mainly because of the risk that it would increase the range of litigation already on foot and would be both speculative and expensive by comparison with this winding up application. So the first point from the Privy Council's judgment in Chu v. Lau is that it's not as obvious as one might think that the availability of a buyout is sufficient to mean that the court will not grant a winding up. There's a lot of negatives in that. In short, a winding up is still a feasible remedy, and the Privy Council upheld Roger Kay as to the petitioner's choice to seek that remedy in the circumstances. But another significant part of the case is that it confirms and highlights the facts that even in non-quasi-partnership cases, there is scope to wind up a company on grounds of what are referred to in Hollington as, quotes, justified loss of confidence in the conduct and management of the company's affairs. Now, that's a term that's taken from the 1925 House of Lords authority, Locke v. John Blackwood, which is cited by the Privy Council in Chu and Lau with approval. And it's an authority for the proposition that the lack of confidence can lead to a winding up as long as it's based on, quotes, a want of probity. Now, want of probity itself is a very loose term, sometimes held to be wider than dishonesty, sometimes not. And there are similar dicta in other cases from the same period. In Thompson v. Drysdale, the second case on my list, another Scottish case from 1925, it was held that a loss of confidence in the, quotes, impartiality or probity of the company's management was sufficient to justify a winding up. And then in the third case of Bird v. Lees, the court referred to an expectation on the part of all shareholders of the company being managed with, quotes, probity and in accordance with the basic principles of fair dealing. So we have impartiality, probity, and the basic principles of fair dealing, and breach of those very loose terms, potentially enabling the minority to seek a winding up solution, even in circumstances where this is not a quasi-partnership. So what that might mean is that even in the absence of the quasi-partnership, you could get a winding up where you couldn't get an unfair prejudice petition to fly. Of course, that depends in part on the scope of the unfair prejudice remedy in non-quasi-partnership cases, and so precisely what Lord Hoffman meant in the leading case of O'Neill and Phillips. And again, we don't have time to debate that, but in short, the question as to whether outside the quasi-partnership scenario, a petitioner needs to show a breach of duty and or some other legally binding agreement in order to succeed. And there are some important points in that debate that are set out by Hollington in Shareholder Rights at paragraph 7-36, if you want to go and have a look, as to why O'Neill and Phillips, which many see as a case designed to cut down the scope of unfair prejudice petitions, should in fact be given a wide and generous reading, and that the term unfair should be kept at large. What is tolerably clear is that non-quasi partners will usually not be able to say there's been a general breakdown in trust of confidence caused by the other side. But Locke and John Blackwood line does not require a quasi-partnership. So you might want to turn there in order to find a solution, even in a non-quasi-partnership case. After all, breach of fair dealing requirements is not a million miles away from a breakdown in trust and confidence type test. So you might be able to get a winding up claim off the ground, even where you couldn't allege a breach of duty or agreement in the non-quasi-partnership case, or where in the quasi-partnership you're in the sort of Edwardian type scenario that there hasn't been a firm enough agreement. But for example, take a board that didn't make distributions for reasons which couldn't be shown to be a breach of duty. That might be sufficient to be a breach of the fair dealing requirement under the just and equitable winding up line of cases, and so found to justify a winding up even where it couldn't amount to unfair prejudice because there was no breach of duty. Now, a consideration of all of this appears in the very recent Jersey Court of Appeal Authority, which I've cited at the end of my case list of FTV v ETFS Capital, where the Jersey Court of Appeal, with Jonathan Crowe as president, preferred a very wide interpretation of both the unfair prejudice regime and of this winding up jurisdiction along the John Locke lines. The petitioning plaintiffs have sought both remedies in the alternative. The Court of Appeal upheld the buyout order made at first instance, which was made at a discount along the Edwardian line. But it also held that if it were wrong on that, it would have ordered a winding up on the Locke and John Blackwood basis. Now, in practical terms, for litigators, a consideration is that it may permit a non-quasi-partnership petitioner to run a very broad case, taking into account almost everything involved in the history of the company, to justify the supposed, quotes, loss of confidence in management, which might justify disclosure on very significant grounds. And one of the obvious tactics for petitioners to obtain settlements is to try and add in everything in the kitchen sink in order to make the proceedings the nightmare that they notoriously did become for some time. Given the costs of these types of proceedings, obviously such a threat is very meaningful. So I put it no more highly than this. The remedy of a just and equitable winding up should be carefully considered in shareholder disputes. The Privy Council's judgment in Chu and Lau shows that it cannot be assumed that a petitioner ought to pursue the buyout remedy if possibly available, and particularly where a buyout might not be possible because there are insufficient funds in the other side and in the majority. Moreover, depending upon the width of the unfair prejudice regime and how that plays out over the next generation of judicial decisions, it's possible that, even in cases of general misconduct, winding up might be available even where a buyout might not be obtained, surprising as that may seem. Thank you. I'm going to hand over to Sophie now.
Hello. Moving on to remedies in unfair prejudice actions. The purpose of the court's powers when granting relief in unfair prejudice petitions is to remedy the unfair prejudice suffered. And the court's powers as regards the remedies are very wide. It has unfettered discretion to award a range of remedies in order to remedy the unfair prejudice that has been suffered. And this is clear from the terms of section 996, subsection 1 of the Companies Act 2006. The most important and commonly granted remedy is an order for the purchase of shares. This is expressly provided for in section 996, subsection 2E of the Companies Act. The clear and obvious advantage of a buyout order is that there is a clean break in that one of the shareholders or group of shareholders exit the company and let the rest get on with things. It also means that the existing member can realize the value of his interest in the company without having the company wound up. Now, in most cases, there's going to be disagreement over the basis of the valuation of the shares in question. The overriding principle is that the shares have to be purchased at fair value. In the CVC Opportunity Equity Partners and the Marco Almeida case, Lord Millett identified 3 possible bases for valuing a minority shareholding in an unquoted company, which I've set out on the slide. He then said which of these should be adopted as the appropriate basis of valuation depends on all the circumstances. The choice must be fair to both parties, and it's difficult to see any justification for adopting the breakup or liquidation basis of valuation where the purchaser intends to continue to carry on the business of the company as a going concern. This would give the purchaser a windfall at the expense of the seller. If the going concern value is adopted, a further question rises whether a discount should be applied to reflect the fact that the company holding is a minority one. So apart from the basis for valuation, there might also be a dispute between the parties as to the date of such valuation, the instances of unfairly prejudicial conduct for which specific allowances ought to be made in the valuation, whether special allowance needs to be made for discrete assets or liabilities, and whether interest or quasi-interest should be awarded. Now, given the time constraints, I want to focus on the specific issue of whether, where the going concern value is adopted, there should be a discount for minority shareholding to reflect the fact that it's a minority holding. Whether such discount should be applied is often a stumbling block when a majority shareholder seeks to make a buyout offer at fair value, and the reason why proceedings might be pursued. Matters are not helped by the fact that this is an area of the law where uncertainty still prevails. Now, in the case of O'Neill and Phillips that Tony has already mentioned, Lord Hoffman said that the general rule is that no minority discount should apply, regardless of whether the case is a quasi-partnership case with a discount only appropriate in special circumstances. This is still the general approach in the case of quasi-partnerships. In such cases, there is in practice a strong presumption that no minority discount should be applied. See, for instance, the Rebirth Precision Bellows case, in which Mr. Justice Nourse, as he then was, set this out with his judgment approved by the Court of Appeal. Now, the rationale for denying a discount in a quasi-partnership company derives from an analogy with partnership law, in that absent any agreement to the contrary, where a partner leaves a partnership as a matter of law, the partnership will be dissolved. Upon the solution of the partnership, each partner will be entitled to its proportionate share of the partnership assets, and this is the case irrespective of any issues as to fault. So in a quasi-partnership company, it's generally appropriate to value a minority shareholder's stake on the basis of a notional sale of the company's entire issued share capital to an external purchaser, and then to divide the proceeds of sale pro rata between shareholders. Now, whilst that's the general approach, it's of course not of universal application, and the specific circumstances may require a different approach. For instance, where the shareholder has acted so as to deserve his exclusion from the company, or where petitioner has acquired the shares at the price which was discounted to reflect his minority status. And this was recognized by Mr. Justice Nourse in the Rebirth, Precision and Bellows case. But what if the company is not a quasi-partnership? Now, historically, a minority shareholder might still have had good hopes to argue successfully that a pro rata valuation was appropriate. But that, more recently, the position has become far from certain in either direction. Now, the first case that it's worth mentioning is the first one on the slide. This was a quasi-partnership case, and the appeal was against a buyout at full value, which was dismissed. Now, Lady Justice Arden, as she then was, said that normally in quasi-partnership companies, the appropriate approach to valuation is on a full, i.e. non-discounted basis. But she then went on to say obiter that it would be difficult to conceive of circumstances for a non-discounted basis of valuation in the absence of a quasi-partnership relationship. And she added that exceptional circumstances had to exist for there to be a minority discount. Now, some have seen this comment as a presumption, at least in the practical sense, in favor of a discount in companies which are not quasi-partnerships. The rationale is said to be the fact that it's appropriate for a minority shareholder to be discounted to reflect the lack of control conferred by such shareholding. The presumption in cases of quasi-partnerships that there be no discount makes sense because of the analogy with partnership law. But it doesn't follow that there should be a presumption in favor of a discount if the company is not a quasi-partnership. And a rule that is solely based on whether the relationship is a quasi-partnership or not is not a principled or rational one, given that some small companies, which are not quasi-partnerships, are on the spectrum actually much closer to quasi-partnerships than to large quoted companies. There's also, in my view, force in the argument, as various cases have recognized, that where the majority shareholder has, by his unfair conduct, forced a minority out, and the court makes a share purchase order, it would be wrong in principle that such majority shareholder profits from the application of a discount. Now, Lady Arden's comments were followed and applied by Mr. Justice Blackburn in the Irvine and Irvine case. This case concerned a minority shareholder of 49.96% in a company, which had none of the characteristics of a quasi-partnership. The majority control was the result of a gift of a single share to the respondent. The judge in that case held that the minority shareholding should be valued for the purposes of a share purchase order for what it is, with a discount reflecting the minority status. There were no exceptional circumstances justifying departure from that reality. And the 30% discount applied by the judge reflected the fact that although the petitioner was a 49.96% shareholder, his shares gave him actually no greater control over how the majority would conduct the business than, say, a 30% stake would have conferred. The petitioner's holding can block the passing of a special resolution, but can achieve little more, the judge said. And the judge added that the gift of a single share to give control to the majority was irrelevant, as there were no conditions attached to the gift, and the buyout had to proceed on the basis that the respondent was a willing buyer. Now, in light of this case and the approach taken in other cases, it was thought that it would be difficult for a petitioning minority shareholder to persuade a court that a pro rata valuation was appropriate in cases of known quasi-partnerships, unless exceptional circumstances existed. But that's not actually been the universal approach of the courts, and there are three cases here that I want to mention. The first is Sunrise Limited. Now, this involved a small private company, which was not a quasi-partnership. The judge took the view that the recognition of some exceptional circumstance in Irvine and Irvine pointed to the fact that there was no inflexible rule that a non-discounted basis valuation would be appropriate where quasi-partnership relationship did not exist. In this case, he held that the petitioner's shares should be valued without a discount. He took into account, amongst other things, that the minority shareholder had been an original shareholder who subscribed for shares at the same undiscounted price as everyone else, that she was in no realistic sense a willing seller, that the facts could have justified a winding up order on the just and equitable ground, therefore resulting in a rateable distribution, and that the wrongdoing majority shareholder should not be unjustly enriched as a result of any buyout without a discount. The second case is the Reblue Index Limited case. Now, this concerned a company that was held to be a quasi-partnership, but in which the petitioning minority shareholder was a sleeping partner as opposed to a quasi-partner because he was not a director and had no right to be involved in its management. The Deputy High Court judge considered what he described as a conflict of authorities between Irvine and his understanding of Bird Precision Bellows, which I mentioned earlier. He said that in his view, the general rule was that there should be no discount applied in the valuation of a minority shareholder, regardless of whether or not the company was a quasi-partnership, although this general rule could be displaced if it was shown, for example, that the petitioner had acquired his shares at a discount. He also held that he was wrong about that, and that the general rule was as stated in Irvine. He would have held that there were special circumstances which would have made the application of a discount inappropriate, including the fact that the minority shareholder was a sleeping partner in a quasi-partnership, and they would have been entitled to a winding up order. Now, the third case is the Edwardian group case, which Tony has already mentioned quite extensively. And Mr. Justice Fancourt in that case held that there is no presumption for or against a discount where the company is not a quasi-partnership, in contrast to a presumption where it is. He also noted that to apply an open market valuation, as the majority had contended, would give them a very substantial windfall. So not only has Irvine not been followed, but the courts have often tried to find exceptional circumstances to justify a pro rata valuation. Now, given the state of the law, it's obvious that this is an issue that is ripe for consideration by a higher court. Now, the latest word, which in fact does very little to address the uncertainty in the case law, is the judgment of Lady Arden, as she now is, in the Privy Council case of Shandor Games and Masso Capital Investments. Now, in that case, Lady Arden confirmed that if the company is a quasi-partnership, the court will normally order that the shares be valued without a minority discount. And in the following paragraph, Lady Arden then referred to her earlier statement in the Strahan and Wilcock case that exceptional circumstances must exist for the shares to be valued without a minority discount if the company is not a quasi-partnership, although Lady Arden noted that in some later first instance decision, a different approach had in fact been adopted. Now, that comment was again an obiter comment by Lady Arden. The Shandor Games case was not an unfair prejudice case at all. It was concerned with the meaning of the words fair value in section 238 of the Cayman Island Companies Law, a provision which entitles a dissenting shareholder in a merger or consolidation to payment of the fair value of his or her shares. Now, Lady Arden's most recent obiter comment therefore leaves plenty of scope for argument about whether or not there should be a minority discount in companies which are not quasi-partnerships. As things stand, it's clear that the minority shareholder in a non-quasi-partnership cannot, at present, safely assume that he will, on a Section 999 application, automatically be entitled to a purchase order without a minority discount. So if the majority make a discounted offer, it doesn't follow that it is necessarily worth pursuing proceedings because of the substantial risk in a non-quasi-partnership case that the court will in fact order a discount. And even if the petitioner is ultimately able to achieve a pro rata valuation, the question always remains whether the difference in value really justifies pursuing what are costly and in some cases extremely lengthy proceedings. And that's why it might be worth considering other available remedies in unfair prejudice actions. As Lord Briggs recently indicated in the Ming Sui Hung case in the Privy Council, a buyout order is not a preferred remedy in general. Now, Section 996, subsection 2 of the Companies Act sets out a non-exhausting list of other remedies in addition to buyout order. And there are case law examples where such remedies have been given. First, you might think of the option of going for damages for the company or the petitioner. For instance, in the Woodliff case, a shareholder and former employee of a company was entitled to pursue a claim for wrongful dismissal within an unfair prejudice petition presented pursuant to Section 994. The second option is that the court can order to regulate the conduct of the company's affairs in the future. This means that the court can appoint receivers or independent management, for instance, as it did in the 2 Australian cases that I've put on the slides. It's also worth mentioning in this context the Remedies rugby case, which involved a petition and a cross petition under Section 994 in a case of 2 equal 50-50 shareholders. Now, the court held that in the circumstances, it would be disproportionate to make a share purchase order if a less drastic remedy could be devised. And in that case, the court therefore made an order which preserved the spirit of an agreement made at the outset between the shareholders by regulating the composition of the board of the company and a related company in which it held shares to break the deadlock between them. And the Court of Appeal upheld that order. Now, courts have been rather reluctant to make orders restricting the way in which the majority can conduct the affairs of the company, as any such order still constitutes interference with the way in which the company is run. And such orders obviously need to be policed. So although the court's power has been around since 1948, there are actually only very few reported cases. And where personal relationships have broken down, it's often simply not realistic to expect the parties to continue to remain associated. The third remedy one might consider is that the court can grant an injunction or an order for specific performance. Now, this is expressly recognized in Section 996(2)(b) of the Companies Act. And in this context, it's worth mentioning the Sikorsky case. In that case, the court granted relief to enforce an agreement between the controlling majority shareholder and the petitioning minority shareholder, under which the petitioner was entitled to an index-linked dividend funded out of rents payable by another company owned by the majority shareholder. And the court ordered that the company was to demand rent at full rate necessary to fund those dividends and to pay the dividends to the petitioner at the agreed rate. The court made clear that while it had become almost the norm to order the purchase of the unfairly prejudiced shareholders' shares, the court was not to close its mind to bespoke solutions that did not involve a buyout, at least in cases where leaving the parties as shareholders would not perpetuate an impossible joint management relationship. Now, fourth, it may be possible to get an account of profits for the company. And this was the case in Buller and Buller, where following breaches of fiduciary duties, the court ordered an account of profits for the company. That case also shows that the court has power to order a division of the company's assets between the majority and the minority, although on the facts of that case, no such order was made. And such division orders, in fact, give rise to many practical problems, including how to divide the assets and how to preserve the interests of creditors and third parties who may not be before the court. So it's not an order that the court probably wants to make lightly. So all of that to say that whilst the buyout order is likely the most common and useful remedy, there's actually a broad range of remedies available that might be potentially advantaged in a specific case. And it's therefore in each case worth to look at them and at least to consider them, particularly given the current uncertainty over whether a minority shareholder in a non-quasi-partnership company will be entitled to a pro rata valuation without a discount.
Well, thank you very much, Sophie. Thanks also to Ed. I found that extremely useful, actually, and it's good to be updated. One thing that interests me is the 3 cases that Sophie mentioned on the vexed question of discount for minority stake. Sunrise was a decision of Charles Pearl. It's important to note that Charles Pearl was counsel in Bird Precision Bellows, and he'd harbored something of a very principled resentment of the outcome in Miss Justice Nourse's decision in Bird Precision Bellows for about 30 years. And that was his chance to get back to what he thought was a more appropriate way forward. Sunrise is an interesting case and it's worth reading. Blue Index, also Robin Hollington, my impression is that he was on a mission of his own, really. He had very strong views that one should generally have pro rata valuation. And in Edwardian, Mr. Justice Fancourt, it was one of his first cases as a fully fledged High Court judge. He's a property lawyer by background, and so his quite novel analysis of some sort of marriage value, which splits the difference between the two different ways of looking at things, may be explained because of his background. The net result is that it's actually quite difficult in many cases to predict what the court is likely to do, which is something of a nightmare when you're trying to make an offer which is designed to forestall any company proceedings, as does the case that Ed mentioned, the FTV case, really reviving and breathing new life into the just and equitable jurisdiction, and indeed encouraging parties to throw the kitchen sink at unfair prejudice cases.